Hello, hello, those of you who are joining us. As you get settled in and we wait for more people to join us, I encourage you to use the chat. Introduce yourself, share where you're signing in from, also share what kind of creative work you do, and we will get started in just a couple minutes. Welcome, welcome. Introduce yourself in the chat, y'all. If you are settling in just now, I believe someone else just joined. Hi, Deetra. I recognize that name. I encourage you share your name in the chat, where you're signing in from, also what kind of creative work that you do, and then we will get started in just a minute or so. Welcome, welcome. Hi, Annie. Hey, Cynthia, joining us. All right, I'm gonna just kick us off then. Again, y'all, come on. And did I scare everyone when I emailed saying that it's gonna be interactive? But please introduce yourself in the chat, share where you're signing in from, as well as the kind of creative practice that you do so that we know what you're up to. So I'm going to kick us off. Hello, hello. Welcome, everyone. Thank you for joining us for Confidently Informed, Navigating the Copyright Claims Board for Creatives. My name is Jenny Lynn Bailon, and I am the Senior Program Associate at the Center for Cultural Innovation. And I have had the pleasure of working with your trainers, who you will hear more about, on this workshop, as well as the resource that inspired our partnership and this workshop, which is our newly released, as of this week, Navigating the Copyright Claims Board, a practical guide for creators, of which my colleague Lorena is going to put in the chat for you all to check out. So I am signing in from the unceded Chumash land, also presently known as Oxnard, California, and I'm so thrilled to kick off this workshop. So if you haven't already, again, introduce yourself in the chat. We're going to get interactive and chat about all of the types of copyright claims issues that you might be needing to deal with, just so we get a sense of who's in the room with us today. And in addition to introducing yourself in the chat, I'm going to encourage you all to also add your pronouns, adjust your name. Sometimes you sign on and you get a bunch of numbers. We want to make sure we know who our learning community is today. And you can do that by clicking on your video screen on the three buttons on the right, and then hit an edit name, and you can kind of copy how mine is looking. So Jenny Lynn Bailon, she, her, and then I have my organizational affiliation if you feel like putting that on there. So I'm going to ask you all to go next slide. Cool, cool, cool. So this guide was released publicly this week and was born out of a new and ongoing partnership with Stanford University's Jules Gard Intellectual Property and Innovation Clinic, or JPIC. Please jump in if I am actually pronouncing that acronym wrong, actually, but JPIC. That started February of this year. And what do I mean by ongoing partnership? We're excited to share that in addition to this resource that's going to be continuously being updated by JPIC students, we'll also be actively collecting stories from our community of artists, culture bearers, and creative entrepreneurs, and continuing to work with JPIC students to produce resources and or workshops like this to meet the intellectual property needs being expressed by all of you. So please share your stories with us. That's very important. If you're not already familiar with the Center for Cultural Innovation, or CCI, our mission is to support individuals in the arts, artists, culture bearers, and creative entrepreneurs to realize greater self-determination so as to unfetter their productivity, free expression, and social impact. So we do this through grant making, trainings like this one that you're attending, and our new and growing advocacy work, which is where this partnership came from. In CCI's advocacy work, we're on the mission to fully reimagine America's social safety net to really work for all workers. And that includes non-standard gig work, of which is a lifestyle that many artists live on the daily. So we know that really well. We do this through the lens of thinking about how we can better advance protections, opportunities, and power among artists and other gig workers who share their working conditions. And with that lens, earlier this year, CCI approached Phil Malone, shout out Phil, I know you're in the crowd, director of Stanford University's Jules Gard Intellectual Property and Innovation Clinic, about better understanding the newly formed Copyright Claims Board, or CCB as I'll be calling it, and how this new public resource is performing for artists and their efforts in protecting their own intellectual property. And this curiosity brought us to connecting with the amazing Caitlin Carey Burke and Kieran Watnamoir, and the rest is history. Please, next slide. So I will say, and I will keep saying it, my favorite part of this partnership has been working with these intelligent, efficient, and incredibly welcoming law students who made legal speak and copyright less intimidating and scary for me, of which I hope will be the same for all of you today. With Phil and his colleague Nina Sriovic, Vich's mentorship, Caitlin and Kieran researched, wrote, and worked with me and my colleagues at CCI to develop Navigating the Copyright Claims Board, a practical guide for creators, and produce this complimentary workshop to walk you all through the basics of copyright and what role the Copyright Claims Board can play in protecting all of y'all's intellectual property as a creative. So a little bit more about our trainers today. So Caitlin Carey Burke is a second-year law student at Stanford and a PhD candidate in communications, along with being a member of the Jules Gard Intellectual Property and Innovation Clinic. Her research interests are design ethics, data privacy, and online children's safety. And I have just learned today that she is a Taurus. Kieran Watnamoir is also a second-year law student at Stanford and member of the Jules Gard Intellectual Property and Innovation Clinic. Before law school, Kieran completed a master's in design and engineering at Harvard's Graduate School of Design and has ample work experience in technology-focused civil rights and nonprofit. Kieran is also a creative herself, working in production or product design, and branding, and is a fiery Aries. So before I hand it over to our presenters, next slide, please. We're going to go into a little bit of housekeeping. And what I mean by that is we're sharing a space, we're sharing a learning space, and that means we're going to be interacting with each other. So be present to our space and to yourself. What I mean by that is by being present to our space, be mindful of your audio. We know there's a lot going on. We're recording. You can see that right now, but just be mindful of maybe hitting the mute if there are things going on. And as you see, we are recording. This will be posted during breakouts. That will not be recorded. But if you don't feel so comfortable putting on screen and on a recording, feel free to turn your video off. And then in breakouts, encourage you to turn them back on. They won't be recorded. Also, take care of yourself. If you need to go do a bio break, please go do a bio break. We're together for the next 2 hours or so. So we want you to be comfortable. As well as for staying present for yourself, we also really recognize that topics such as finance and the law, that can really kick up super valid emotions for people. And so what I mean by that is if you feel some feelings coming up, you feel some discomfort, it's bringing you back to maybe a difficult situation you may have had, be kind to yourself, pause, take a breath. Let us know if there's anything that we can do to hold a good learning space for you all. So for tech or general help, I'm here with my colleague Lorena Moreno. You can feel free to reach out to either of us, so Lorena or Jenny Lynn in the chat. We can help you with honestly whatever was within our power. If there's any tech help you might need, let us know. But also if there's a way that we can help the learning space too. So say, hey, actually, could you speak a little bit slower? Could you adjust your volume? Things like that. We'll always do our best. So feel free to reach out. We're here to make this a good experience for you all. And then as far as questions, please put them in the chat. We're going to have a maybe two designated, for sure one designated question section. But if you put your questions in the chat, Lorena and I will tag team to make sure that they will be answered whenever we have our designated question section. And then finally, I always really love saying this, story stay, learning leaves. So as I mentioned, we'll have some activities where you're meeting other colleagues who are interested about copyright. If they decide to share any details about personal experiences, anything of that sort, please keep those details here, but any kind of learning nuggets that can go. So, respect people's privacy of what they decide to share with you all today. And so with that, I am going to pass it over to Caitlin and Kieran. Thanks, y'all.
Thank you for the introduction, Jenny Lynn. So today we'll be going over a couple different topics. We'll start by talking about what intellectual property is, and then we'll move into explaining what the Copyright Claims Board is. And then we'll start talking about how to file a claim with the CCB. And throughout our presentation, we'll perform a couple different breakouts so folks can get to meet each other. And we'll end with takeaways and, of course, questions and hopefully answers as well. So we're going to start with a breakout, and we'd like for everyone with their partners or partner to discuss what they already know about copyright and copyright law, and then maybe just talk about some things that you are curious about, so things you don't totally understand or would love to talk a little bit more about. And then in the breakout group, also assign someone to share out when we come back together what was discussed.
All right, so breakout rooms are created, y'all. I'm gonna pause. All right, welcome back, y'all. Why don't you share a little bit of what was discussed in the chat, as well as maybe if you had someone assigned, please maybe raise your hand and we could have someone share your virtual Zoom hand. Go ahead, Cynthia.
Apologies, I'm feeling a little camera shy, so I'll be off camera.
Okay.
But I'll just share what I shared with my little group is that I feel like I just know very basics about copyright. I don't even really know like what I do know is that it differs from country to country. So I'd be interested to like learn more about that. And then in the US, what I do know is that like artists can also use trademark law. So I don't know if we're going to talk about that at all. And then from my perspective, I'm actually not an individual practitioner of a creative practice that like I would be trying to protect, but I work with artists and coalition organizing, and would love to pass off this information to folks that I work with.
Thank you for those comments. I don't think we cover international or trademark, but it's a great note for future students as well to maybe consider that moving forward. We're not covering today, but it should be covered in the future. So I think maybe we can go next slide.
We've got one more
Oh, one
bug
more
on.
hand.
Anna, would you want to share your story or the things that you're curious about?
Yeah, so I am especially curious about how generative AI will work with copyrights. I think that's probably one of the most pressing issues for a lot of artists right now. And I think there are a lot of questions around fair use. So I really feel that's an area that artists can use a ton of support around. Because for many of us, it does feel like an existential crisis.
Oh. That's such a great point, and we do talk about that in the guide a little bit, and we can get into that later as well. But yeah, it's a really interesting topic, and we talked a little bit too about NFTs, so we can address that towards the end of the presentation. A great question, thank you.
There is also one in the chat as well. It says, my group is interested to see how copyright will apply to AI generative art. Thanks, Alice, for that comment that you noted there.
Awesome, thank you, Alice. Yes, and so yes, we will talk about AI. These are great questions, and we're excited to get into it today. And of course, before we move on to more of the substance of our guide on the CCB, we just want to make a quick note that this advice today is not legal advice. So this is solely for informational purposes. We advise everyone to kind of take the information as is, and then, you know, be careful applying to your own situations, as every scenario is different. Everyone has a different kind of copyright scenario, and then consider getting advice from a licensed attorney in California or in your jurisdiction if you have any specific legal issues or problems.
All right, let's get into it. Also definitely seeing some of the questions and comments in the chat. And we will talk a little bit about sculpture and video. So yeah, let's move on ahead. So we wanted to start sharing a very, very basic primer on copyright and intellectual property. Many of you all probably already know IP, or intellectual property, refers to creations of the mind. So things that people can invent, or artworks. And IP, intellectual property rights, allow people to protect their creative work by preventing others from reproducing it or exploiting their creations. And there's many different kinds of intellectual property rights, and we've already touched on this in your notes in the beginning, but there's copyright, trademark, and patent. Of course, today we're going to talk specifically about copyright. So copyright, again, is one form of IP. And if you imagine that you're an artist or a painter in this case, let's say that you've just finished this landscape painting. Can you protect this? And what rights do you have on this painting? Also, fun fact, this emoji actually is protected by copyright as well. So there's layers to the presentation. But yeah, when you finish a painting, the work is fixed. And what fixed means here is that it's actually like tangible. It's completed in some sort of medium that's going to be like long-standing. It's not just going to disappear or like dissolve or something. And because it's fixed, it's now capable of being perceived by other people and also reproduced. So now it's, because it's fixed, it's given in the United States at least, automatically something called a copyright upon fixation. So if you've ever completed a fixed artwork, you actually already have copyrights. Now, just to note, copyright upon fixation is this very specific thing. This copyright gives you the right to register your work for a copyright with the US Copyright Office, but it doesn't actually give you legal rights or protections. So basically, once you fixed a work, you're the author, you're the creator. Now you get the rights to go and register that work, and nobody else can register it except for you. So quick pop quiz. Oh, actually, I think we might pause on this real quick if we can, and jump into the next slides.
Yes. Yes, so as Karen was mentioning, there's a difference between registration and fixation. And by registering your work with the Copyright Office, you earn legal protection. And this means that if someone infringes your work, you can bring a claim against that person. So as a quick reminder, infringement means that someone copied your work in a way that took key expressive elements. And there are some additional notes about copyright registration that pertains to your specific copyright. So a reminder in that sense that copyrights do expire and they typically last the life of the author plus 70 years. And there is a cost to copyright registration as well. A registered copyright gives you a couple different protections and authorizations. So one is the right to make copies. Two is the right to prepare other works using this works or derivative works. Three is the right to distribute the work, and four is the right to publicly perform or display the work. And this pertains to, for example, theater or musical pieces. So now we will move into a quick pop quiz. And we would like to ask everyone, so in this case, you just created a new sewing pattern, an original dress design. And do you think A, that this creation gives you copyright upon fixation, B, you registered copyright, or C, no? So does this dress original sewing pattern have copyright? I think we see, so three folks participated, and if you see, yes, awesome. You just click the buttons in the poll.
The button actually doesn't have the option for C, by the way, on our end.
Oh, thank you.
Oh, my apologies. I appreciate the creative solution in the chat, though. Shall I share results?
Sounds good.
Looks like most folks picked A, and that is the correct answer. So yes, copyright upon fixation. So as soon as you finish the sewing pattern and original dress design, you have copyright, but you do not have legal protections under the registration of that copyright. Okay, so next, quick pop quiz question. Can you legally defend your work? So let's say someone copies your dress design after you posted it to Instagram, and now they're selling it on Etsy. So A, do you think you have copyright, or B, that copyright isn't quite enough?
Oh, we're so close to getting everyone. We have 5 more people. I'm going to end the poll and share.
Okay, so looks like most folks picked no, but we do have some people that picked yes. And the correct answer is no. So that copyright isn't quite enough. So this kind of goes to the issue we were just talking about, which is the difference between fixation and registration. So at this point in time, without a registered copyright, you would have difficulty bringing a claim, say, through the CCB.
All right, so we're going to move on to some common terms. Also, if anyone has questions, please feel free to ask them in the chat. We'll pause for a few breaks also in between, but we just want to make sure that we're bringing everyone along with us. Yeah, so we will share a couple of basic terms. You probably have heard some of these before, and these are a little bit more like in legalese, and so we just wanted to help fit them in different examples. So a claimant is a person who files a claim, who has something happen to them, like a legal injury, and they want to make things right for themselves. And a claimant will file a case against a respondent. So the respondent is the one who's on the other side of it, who might be potentially an infringer or the recipient of this complaint. And as a claimant, you'll be seeking relief in the form of damages. There's different kinds of relief that you can seek from a court, but in this case, we're going to talk about damages. And damages are basically like different kinds of money awards. Statutory damages are awards that are based on the law. So sometimes, depending on what state you're in, traditionally, there are fixed costs and maximums and minimums, for example, for how much you might be able to get in a federal court if you were to bring a copyright claim. And actual damages are based on the losses that you personally suffered. So while statutory damages are just like numbers that are fixed in the law, these are based on your receipts or like your losses. So maybe somebody infringed on your designs and they made a certain amount of profit that should have been yours. Those are losses now that you've had. So you might go file a claim because you want actual damages. So that was a lot of words. We're going to march on a little bit more and we'll pause in a couple minutes. But so there's different kinds of copyright claims. One of them is infringement, which is the most popular one, the one you might have heard already. This is when you believe somebody is using your original and protected work and using your exclusive rights in that bundle of rights we talked about without your permission. So imagine you're Priscilla. Priscilla is a painter who posts photos of her works online, maybe on Instagram, and she noticed that a print of her painting was being sold on Amazon. Of course, without her permission, she just discovered this, and she wants to be repaid for that lost profit that she should have had. She might have an infringement claim in this case. Next up is non-infringement, which is kind of the opposite of infringement. Basically, you want legal proof that you are not infringing on somebody else's protected work. So maybe you're a jewelry designer named Jiyoung. Let's say that Jiyoung was delisted from Etsy and she learned that somebody reported her work as copying them, but she knows that she did not. And she wants to restore her work in her Etsy store back online. And she wants to be paid for the lost profits that she might have had and the peace of mind just that there isn't going to be future legal action against her. Jiyoung might just want like a piece of paper that gives her the security to say like she is not infringing on this other person. That's what a non-infringement claim is. And last type of claim is misrepresentation. It's when you believe that somebody said something false while reporting your work to be taken down online. And you think that a website then acted on that false information and delisted you and took your content away. So let's say Margot posted her music onto Spotify and found out a couple months later that one of her competitors kind of lied and falsely told Spotify that she infringed on their music. Margot feels that this is only an action that was made to threaten her success and her music, and she thinks that this claim isn't really real. She just wants the truth to come out and for the right information to be acted upon. And so she wants Spotify to know that this is not true, and she wants Spotify to put her things back online. So those are the three kinds of claims that we will be going over today. There might be a couple other things, but those are not types of claims that you can bring to the Copyright Claims Board. All right, so time for another pop quiz. And after this section of quizzes, maybe we'll pause for a few minutes just for questions. But this first question, Caitlin, do you want to take the ropes?
Take the pop quiz? Sure. So our first question is, what kind of claim could this be? So in this scenario, you're about to perform an original play you wrote. Someone tells you to cancel the opening performance because they believe you copied their work. So do you think this is an infringement claim, non-infringement claim, or a misrepresentation claim? I think we have everybody. Almost 66%. Almost there. So it looks like most folks noted misrepresentation and then non-infringement and then infringement. And the correct answer is a non-infringement claim. And we will talk about this too in a little bit.
And yeah, maybe to clarify on this one, this is a case where somebody is now having to change their own plans because somebody else thinks that there's infringement here. And if you are wanting to continue with your opening performances and you believe that there's no issue here at all, you want the court to basically give you insulation and confirm that this is not infringement. There is no legal problem here, and you should be able to continue in your plans because there's no issue.
Exactly. So again, what type of claim would this be? So you posted a YouTube video with an original song you wrote years ago. It was delisted. Someone reported the video claiming you used their newly released music. Do you think this is an infringement claim, non-infringement claim, or misrepresentation claim? Okay, so most folks said misrepresentation, and the correct answer is misrepresentation. So indeed, this is a misrepresentation claim.
All right, we know we just went over a lot of terminology and just wanted to pause really quickly. Does anyone have questions on these definitions? We also can, just wanted to remind you all, you might have a copy of this presentation in your email as well. So if you ever want to refer back to it, you can have all of the glossary and the full context also in the guide that we released. It's also available.
Yes. So pause for questions. Yes, Cynthia.
Can you kind of quickly summarize what the main difference between non-infringement and misrepresentation is? I feel like they're similar in some ways, but not quite the same. Like I got the answers right, but like I couldn't put my finger on exactly why.
Yeah, I think one of the major ones is that for misrepresentation, we're dealing specifically with online service providers like Etsy or Spotify or like some third party that is choosing to delist content because other people are reporting things to them. So this is like fully outside of a legal system. It's like somebody's like filing complaints with like a third party basically. And in misrepresentation, there could be all kinds of false allegations there or just like false information that's shared. So it's not necessarily about infringement, but it could just be reporting on other false data. Whereas infringement is explicitly about like, there is this specific set of rights that somebody gains by registering their copyright, and you are alleging that somebody else used one of those exclusive rights without your permission. So this is very specific to like the way that a work is reproduced or shown in public or copied or edited or something like that. But this doesn't need to be on like Spotify or mediated by some other third party like online system.
And I think to add to what Kieran just mentioned too, I think something that happens more in a misrepresentation claim, as Kieran noted, we're thinking about someone flagging something on Spotify or Etsy or YouTube. And in those cases, the flagger probably knew that the claim was false. And so there's a sense of maybe that they not were acting in bad faith, but maybe acting in a way that there was misunderstanding about the flagging, whereas in a non-infringement claim, that person likely believes that there is in fact some type of copying going on. Yes, I think Annie has a question too.
Hey, sorry, I am still stuck on fixation versus registration because I was told in college when I studied this many, many years ago that as soon as you put something in a fixable form, you have full copyright protection. And that registration formalizes that in a way that it can be represented through courts and more business and legal proceedings, but that you actually don't gain any rights by registering. You just gain like a visibility in a system that everyone agrees on.
Mm-hmm.
So like if you don't register, it can be hard to prove like when fixation happens, for example, which can be key. But if you never register, if you can prove that when fixation happens, that you haven't actually lost any rights. So is it true that it does not give you legal right? Like as soon as something's fixed, it's not legally protected? I'm confused by these two terms.
Yeah, that's a great question. I think you actually just summarized it really well. So you do have copyright rights upon fixation. So like the minute I finish my painting, I own the copyright of that work. But in order to bring a claim, say, for example, through the Copyright Claims Board, you need to have the work registered. So it's exactly what you mentioned, that legal protection is endowed through the Copyright Registration Office. And that doesn't take away or necessarily add to the rights, but it does in a legal framework, as you noted as well.
So, sorry, just to follow up on that. So is it accurate to say that if someone, like an artist, never registers a work and then they feel like it's been infringed upon, they can then that moment register it, wait for the registration to go through, and then file an infringement claim? And it will be, and the copyright will go back to when the fixation date is?
So I think from my understanding, and Kieran, correct me if I'm wrong, the date of registration is when you are able to, so I think this is actually, there's a case law issue here. So fixation as opposed to registration. And I do think it can kind of depend on the court, but my understanding is the registration date is the date at which you own legal protections. And so I think it's difficult to bring a claim about something that was fixed prior to that registration date. I think that's an issue that would have to be debated, is my understanding. But Kieran, you please correct me if I'm wrong on that.
I think one thing I would add is also just to respond and address Alice's question as well. Like fixation is a way of limiting who is allowed to register for the copyright protections. And so the purpose of fixation maybe is to kind of designate your rights, but it doesn't let you get into a court. So yeah, as you said perfectly well, if you do sense that you have an infringement claim and something is going wrong and you might want to file a claim in court, you can still register for a copyright and have it pending. And so sometimes like you might still go over with registration, even if it's a little bit a ways from when you created your work. But yeah, as you mentioned, also there might be benefits to documenting it really early because now it's kind of solidified with a legal entity that you finished this at this time. So there are some benefits from this sort of legal and like documentation lens. But sometimes it might feel like even if you have these rights, if you can't really enforce them through a legal system, then they are a little bit weaker. And so registration gives you a bit more protection in that. All right, maybe we'll move on then to our intro to the CCB.
Yes. So what is the CCB? The Copyright Claims Board is a panel of 3 officers whose goal is to expand access to copyright protections. You can bring your copyright claim fully online through the CCB as opposed to in court. So that's the major difference with the CCBs. This is a fully digital system. Through the CCB, you can bring an infringement claim, as we mentioned, a non-infringement claim or a misrepresentation claim. And we will go into how to kind of bring those different types of claims in a little bit. But an important note is that you can only receive a maximum of $30,000 in damages through the CCB. So as opposed to federal court where there's a different damages cap, the CCB caps your damages allotment at 30 grand.
We also just wanted to shout out, we might have a couple of guests in the audience who are from the Copyright Office. So if anybody wants to say hi or step in, yeah, we would love for you to chime in if you want to add anything as we go through this.
So the CCB has seen cases and claims related to a wide variety of works. The most commonly brought claim relates to pictorial, graphic, and sculptural works. And I know we had a question about that as well in the chat. Second, I guess surprisingly, is a motion picture related work. And third is a literary work. And so you can kind of see the breakout here of the different types of works that the Copyright Claims Board often sees.
So Caitlin already mentioned this before, but there are a lot of different trade-offs depending on where you might want to bring a legal claim, if that's something that you decided you want to look into. And these are sort of your 2 main options. There's the Copyright Claims Board and federal courts. Now, with the Copyright Claims Board, it was kind of designed to be more lightweight and simplified. So it's simpler procedurally, and so much so that it's designed so that you don't need an attorney to navigate the process. It's fully online. Even the claims forms are all digital. And so you can do this without a lot of physical paperwork and worrying about the mail or other delays. And the hearings are also fully virtual. Now, if you really value being able to appear in person, the federal court option might be better for you. But yeah, there's a bunch of different trade-offs going on. So fees are a bit cheaper with the Copyright Claims Board. The Claims Board is also decided by a 3-member panel of copyright experts. So if you brought this same claim to a federal court, you might run up against a judge who is experienced with several different forms of law, but they might not be an expert on copyright because it's not what they're doing all day, every day. And lastly, as Caitlin mentioned this, for damages, if you are if somebody has willfully infringed your work, meaning they knew that they were infringing and they still did it, you might be eligible for much more in damages than you would be if you were at the CCB. There is a cap for $30,000 per proceeding. Yeah, so there are a couple of different trade-offs here, but the Claims Board was designed again to open up access and make filing copyright claims easier for people like us who are creators. And some more details, you can only file CCB claims against people who live in the United States, and you'll be asked to provide an address for them when you initiate a claim. So that's something that you want to make sure you do. Your claim will be dismissed if it's not going to meet that. And the second thing that might be really surprising, definitely was for us, is that it's a voluntary process. So if you were filing a claim against somebody, they can choose whether or not they want to participate in the case. If they decide that they're going to opt out, once they get notice, the case ends at that point. So you might imagine, well, why would anybody choose to opt in? You can still proceed in a federal court afterwards if the person opts out. And so a federal court could be a much more expensive process. Your respondent might have to get an attorney. It might take a long time. It might require travel and managing time off of work, a lot of logistics. And so sometimes it could be better to participate in a simplified process, but this is definitely something that can end a case. And last thing that we wanted to share before we dive into more specifics is a high level picture of what the process looks like. So if you decide to go through with the CCB, you will start with filing a claim. In the data that we analyzed, which is not fully up to date, but ended around February, there were 721 claims filed in total. And those claims have to survive this next major hurdle, which is called compliance review. And that's when the CCB officers review your claim and they check to make sure that you fit all of the criteria for eligibility. So things like that your respondent lives in the United States. They want to see also that your claim is actually viable and that you would be able to back up every required element in your case. Once discovery opens up and you have to submit more evidence, they just want to make sure you have a strong enough claim. And you'll notice that not a lot of claims passed on their first try. And this is because of several reasons. One of the primary ones is that people aren't meeting the eligibility rules here, but another is that a lot of the claims are not meeting the elements. And we'll talk about that in a little bit. The next stage is service. This is when the claimant lets the respondent know that this case is filed. This is traditional for other cases or outside of the CCB as well. And service actually mirrors the same state laws that are applicable for bringing a case to a federal court. So this is one of the more procedural and more kind of legalese oriented steps in this process. It was not redesigned for the CCB. And there are several rules around service. We'll go over those briefly as well. But 361 filings submitted proof of service, which allowed them to move on to the next stage. That's when a claimant kind of has to realize if a respondent will choose to opt out or continue in the case. And a respondent, if they are quiet and they don't say anything, they're automatically opted in. But if they do decide to formally opt out, then the case ends there. And 75 respondents who got to this stage opted out. Now, the final things, we won't be going through as much in depth because these top steps are really the major hurdles to getting in. But there is another payment for a fee. Once you pay that fee, your case moves into something called the active phase, which is when the actual substance of your case is going to be evaluated. This happens in proceedings like you would expect in any other case. So there's responses that are filed for the claims, discovery to bring out more information and evidence to the case, help with fact checking, and then there could be a final determination. And only 12 cases reach that point. So you can see that there's a pretty big funnel kind of happening down here. And so we're maybe left with this big question of why do so few claims reach this final determination? It was 12 out of 721. Also, we're noting the questions in the chat. We will address them as we get to those points in the presentation. And on the question about time period for the CCB data, I can pull that up in a minute. All right, so we'll move on to the next section.
Yes, so as we move into our next section, we'll be discussing various considerations for creatives as you navigate the CCB. And as a quick reminder, so I know we just gave everyone a lot of information. The CCB handbook is online at ccb.gov. And it provides everything we're discussing here in greater detail. And then our guide as well has the information we're discussing here today pertaining to bringing different types of claims. And so if there's ever a question about anything we discussed today, resources are available post discussion to learn more about these various hurdles, for example. So as Carrie mentioned, there are a few different hurdles that occur during during bringing a claim through the CCB, and one of those hurdles is the compliance review process. And so, for example, 334 claims passed compliance review on their first try out of a total of 721. And there are a few different reasons why claims don't survive this first compliance review process. So one example of why claims don't survive is that the claimant may not be bringing the right type of claim. So as a reminder, claimants must bring infringement, non-infringement, or misrepresentation claims. If you're not bringing one of those three types, it won't comply with the CCB process, and so the CCB can't govern on that type of claim. Another reason that claimants sometimes struggle in that first compliance review step is the claim is unsuitable for the CCB. So, for example, as we'll discuss in a little bit, maybe perhaps the claimant forgot to attach the right types of materials to their claim, and that makes their claim unsound for the CCB, and the CCB can't rule on that claim. You may also be asking for a type of relief the CCB cannot provide. So if, for example, you're asking for more than that 30K in damages, there is that cap at the CCB, and they can't provide that type of relief, and your claim might be rejected for those types of reasons. And lastly, again, if you did not provide a very detailed statement of material facts, so say, for example, you didn't provide facts tying your original work with the infringing work that demonstrates that there was some type of infringement on which the CCB can rule, the CCB might reject your claim or ask you to amend the claim in that first compliance review step. So we'll go over all of these in more detail in this section. So again, as a reminder, the CCB can only review infringement, non-infringement, and misrepresentation claims. And sometimes there are claims that seem like they might be a copyright dispute, but when you boil down the issues of the claimants, it's actually maybe a different type of dispute. So one example would be a contract claim. So if, for example, you license your work to someone and then they license that work to another party without your consent, this could be for, more of a contracts dispute and not necessarily a copyright claim. And again, the CCB does not have authority over those types of issues. Another hurdle is the unsuitability. So, for example, when you file your claim, it's necessary to meet certain requirements of that claim. And if any of these are not met, the claim cannot be reviewed by the CCB. So the first requirement is that you and your respondent live in the United States. So you both need to be in the United States for the CCB to have jurisdiction over your claim. You also need to bring this claim within 3 years of when the conduct began. So there's statute of limitations on the infringement and how the CCB can oversee the claim. You must not file more than 30 claims in total with the CCB within a year. So if you exceed a certain number of claims with the CCB, you will likely be dismissed. You also have to have the right to file this case. So again, referring back to the fixation and registration issue, and thinking about your copyright registration, you must have that registration number, for example, available when you file your claim to demonstrate that you own the copyright that you seek to enforce. And then lastly, if you previously filed this claim and it was not dismissed with prejudice and you did not reach a final determination with the CCB in court or with the CCB or in court, you will also be deemed to have an unsuitable claim. So when you file a claim, you will be asked to provide context and explain the facts of your case, and this is called the statement of material facts. So you'll add, for example, in a text box, your point of view as to why the respondent infringed on your original work. And in this text box, you will attach examples of why you think, for example, that person might have infringed the work. So you might state something like, the attached image demonstrates the same pattern as my original work created on this date. and the pattern similarities exist in the color, size, and sequencing of the patterns. So between the two works, it's helpful in your statement of material facts to give reasons why to the CCB that you think this other party may have infringed. And this will help the CCB understand your claim and will help them to understand each element of your claim. And each element varies depending on the type of claim you bring. So whether you're bringing an infringement claim or a non-infringement claim, there are different elements that are important to attack in this statement of material facts. And you will also want to supply evidence and documentation to show why the facts are on your side for each of these elements. So again, thinking about other types of media like screenshots and attachments and documents, that will be helpful to kind of add to your statement of material facts to show how you hit upon all the different elements. In an infringement case, it's important to hit on 3 different elements. So the first element is that you have valid ownership or a registered or pending copyright with exclusive rights over that work. Things you might want to consider are whether or not it was a work for hire. So if it was in fact a work for hire, it may not be yours to copyright, and it might be the partner or your company, for example, who owns that copyright. Another piece to consider is, did you assign those rights to anyone else, or if they're exclusive? So if you did license your rights to someone else, you may not have exclusive ownership of that copyright at that moment in time. And then again, thinking of your registration, it's always nice to have your registration number on hand to add that into your claim at the CCB. A second element of an infringement claim is whether or not an infringer used at least one of your exclusive rights. So, for example, you would want to demonstrate that exclusive right that you own and how the infringer used that exclusive right in a way that is conflicts with the copyright registration that you have. So you would need to explain which right that is and how they used it that is in conflict with your copyright ownership. And then the last element is infringing works that contain substantially similar elements are important to demonstrate. So how is the work similar, and was this other party aware of the work before they copied yours? So for example, you might want to say for that work was on Instagram, and maybe that party is a follower of yours on Instagram. So you can kind of claim that they were viewing the work prior to when they created their own infringing work.
All right, so that was a lot of information. We're going to pause real here for a little recap. So wanted to pop quiz again. The prompt this time is, let's say we have a graphic designer who found that their work was printed on a t-shirt that was being sold online without their permission. What kinds of proof could the designer bring to show that this was in fact infringement? What sorts of records or screenshots or, you know, receipts or things like that could they bring up in this case? And we'd welcome everybody to actually just share in the chat if you have any ideas on this. And also, if you feel like you don't know, like the document that exists, maybe you have a question, maybe that this question prompts instead. And if there's more information you feel like you need to know, that's also totally valid. All right, so we're seeing a couple answers now. Annie mentioned copyright registration for the original work. Totally a great one. Screenshots of the copied work. Yep, it's very helpful to bring all of the context to your case. So if you can show, you know, side by side what the comparison is. Yeah, blueprints to show the original date of origin, to show maybe you had this way earlier than the t-shirt became available online. Great, yeah. All right, so we're gonna share some examples that we thought of earlier, definitely overlapping with a lot of the things y'all have pointed out. So things like screenshots and links to when the designer posted their own content online and where it became available on a storefront later on. Oh yeah, time-lapse video is great. Great proof that, you in fact went through and made that work yourself. Timestamps of when the work became available for sale online. Again, painting the story in the timeline so that you can prove that like you did all of your things way before this became available later. Images of the design side by side so you can kind of point out all of the similarities, and proof that the t-shirt seller maybe followed you on social media, maybe they liked your post. If there's some way for you to know that they were exposed to it before, that could also help. All right, so we're going to move on to non-infringement elements this time. The first major element is that the respondent told you that your activities were or will be infringing on their copyright. So you want some sort of proof that they have made this allegation to you. The second claim, or the second element of the claim, is that the respondent filed a takedown notice with some sort of provider. So if you can kind of show that if there is a third party involved, that they then also tried to act on this and they tried to get it delisted, you want that. And then the respondent's actions have now interfered with your own activities. You have to show that somehow you were actually impacted by this claim, that you actually had to change something about what you were going to do because you were affected by what the respondent was claiming. And the last thing is that the respondent told somebody else about the alleged infringement. So you want proof that maybe they're shouting it out on Twitter or some social media, or told another friend. Of course, those things are going to be harder to get access to depending on where those communications happened, but you want to share some sort of proof that they're also telling this broadly to somebody else. So we're going to enter another pop quiz. This time, the prompt is that Spotify removed your music because another artist claimed there was infringement. How might you show that you did not actually infringe on that artist's work? What kinds of things would you bring up to prove that your work is in fact, original, was not an act of infringement? Yeah, so in the chat, we're getting a couple of great answers. Yeah, a lot of attention on like dated uploads, just proof that you in fact had the working files, that you were responsible for creating this, and examples of how like maybe you entered an agreement with somebody else to make it. If you uploaded this to an app, can you show the timestamp that you did that? Yeah, these are all great answers. And all of these get to that sort of nexus of just like, how can you show that you actually like did the work, that you made this and it happened way earlier? Maybe your music existed before this other person's did. All right. And some examples we came up with that do mirror a lot of what y'all are saying is that you created you have the original files of your work, so you can show the sort of editing and thoughtfulness that went into it and that you actually made this yourself. If you can show that you somehow published the song before the other artist did, how could you have copied it if yours came first? And the last one is you explain how your song is actually meaningfully different from the other song. Maybe there are a lot of ways that your music actually is really original, and you want to kind of clarify that it's not a copy because of these reasons. And in music, I think there's a lot of times where a motif might repeat because it's just common. And maybe it's not actually that unique. You might want to explain how your song isn't really infringing in that way. All right, so last one is misrepresentation. There are 4 elements for misrepresentation. So the first one is that the respondent filed a takedown notice that incorrectly claimed that you infringed. So again, just like we discussed in the earlier questions, there is a lot of overlap here between non-infringement and misrepresentation. But the ultimate result that you want for misrepresentation is that, you know, there was some sort of false information, you want it to be corrected and you want your information to be relisted online. Like you don't want your content to be taken down. So in this case, you want to first show that there was a takedown notice based on false information. The second one is that the respondent knew that the claims they were making were false. And that's really going to the misrepresentation part of this. How can you show that it's not actually true and they knew it? The third one is that the online service provider actually relied on that information. So they made their decision on the basis of this false premise. And the last one is that you were actually harmed as a result. So did you lose money in some sort of tangible, measurable way that you can prove? It's not enough to sort of abstractly just say that this happened to you and now your content isn't online. You want to show what happened as it sort of impacted that. All right.
So we're going to do another pop quiz. So similar to our last pop quiz, share your thoughts in the chat. So for example, an image of your artwork on Instagram was flagged and removed for alleged copyright infringement. How would you show the CCB that your content did not infringe? So what are some examples of how you might show the CCB this non-infringement or that you did not infringe in this case? And maybe if this one's a little harder than the last couple, we can talk about it more. So maybe we can review some of the solutions. Yes, brains have been melted today. It's a lot of information.
So I think maybe before we unpack this question, there's like, I think the reason that this question feels particularly hard, at least to me, is just that there's so much overlap between these different claims, and at least the types of things that we're asking for you to think about for how you prove it. And there's also a feeling of a lack of control sometimes. I think for misrepresentation, that's particularly true because you are now also relying on a lot of internet services that are kind of making their own decisions about what content they're going to flag or how they're going to respond.
Mm-hmm.
And because they're kind of catering to a really, really large volume of users, you're probably not going to get like the human attention or verification you always want in those processes. And so it can feel very unfair, especially when, you know, somebody's bringing false information to get you like deplatformed in some sort of way, and then you feel like you just want to correct it. I think, yeah, and so there's a major tension there, and definitely a feeling of unfairness, which I think a lot of Lizette's questions are sort of getting at, which is like, shouldn't the onus be on the person who's making this allegation in the first place? But just because of the nature of these online platforms kind of needing to make all of these really broad content moderation decisions, this area of law has sort of like kind of been here to catch some of those cases. But yeah, I think there is a lot of tension about the scale of this kind of problem.
Yeah. Yeah, I think Karen said that really well, and I think when we're kind of in the misrepresentation realm, we're usually thinking about like a content moderation issue. So like that button that we all see on Instagram of say, this is not appropriate because of X, and then you're given that drop down. And one of them, I believe, is for copyright reasons. And so let's just say that you have your work up on Instagram over X number of months, and maybe there's one bad actor who's following you who continuously is trying to remove your works. We're thinking about things that we might do in this space as opposed to a non-infringement claim that would help buoy that claim. So things like DMs and screenshots of maybe internal messaging with that company, which is a little bit different from that non-infringement claim.
All right.
Yes, so exactly what we just mentioned. We also had a good comment. I think Google, Spotify, they may remove work first and ask questions later, and that's exactly right. So maybe, for example, timestamps of when you first posted your work, and then when the person claimed, when the person claiming infringement posted theirs, and then if you watermarked or added a signature to your work, does that appear in theirs too? So examples of how maybe like a digital watermark might demonstrate that the two works are not the same. And then, like we were also just mentioning, you could also add those DMs or screenshots with the company demonstrating, or were you trying to prove that that work was not an infringing work? You could add those, to example, to your CCB claim.
I also just I thought maybe one other clarification we could add about the difference between misrepresentation and non-infringement is that non-infringement is kind of like a way of getting peace of mind. If somebody keeps kind of telling the world that like you are infringing on their work and you just want to stop it once and for all, and you want to bring it to court and give them the onus to prove it, this is a way to get a final decision from a legal entity that you are not infringing on their work. So it's like a great way to sort of resolve maybe a conflict that you're experiencing, and you just want like a final sort of decision to answer it so that you don't have to worry about it in the future. So it's kind of getting at a different outcome. All right. So one other hurdle, Caitlin, I'll pass this back off to you.
Yes. So this is a tough hurdle. So this is about serving the other party notice. So let's say that you bring your claim, the CCB approves your claim, and you do need to provide the other party, the respondent, with an opportunity to respond to that claim. So this is called serving the other party notice, and the CCB will provide you, thankfully, with a package of materials for service that you must use to provide the other party with service. It's important just to note here that you cannot change or add materials to this packet. So the CCB is going to basically provide you with everything you need to serve the other party. It might seem intuitive to serve the other party yourself. So you might want to say, oh, I know this person, I'm going to give them that material, but you must hire a separate party to serve notice. So you can hire a service processor to do this for you. You can check the rules of the state of where your respondent lives for their service rules, but say, for example, that other person lives in a different state. Each state has their own, each jurisdiction and state has their own service rules. So you might just check those rules, hire a service processor in that state, and then use the packet of materials to serve the other party. And hopefully the respondent may waive this step, and that this is an option to them through the CCB. So if they do waive service, then you don't need to go through these steps. And we also wanted to just note, so another hurdle that does tend to come up is deadlines. So many claims do end up getting dropped because of missed deadlines. So it's good to remember that you must submit payments on time. If your claim succeeds the first few steps, you'll be given you need to pay a second fee other than that first fee. So it's the CCB will remind you of that fee, and it's important just to keep that in mind. The CCB will serve you or email you a service order with the dates of your hearings. Remember to check emails and dates if you need to amend your claim. So for example, that first hurdle, you maybe didn't provide enough information in your statement of material facts. The CCB does give you the right to amend the claim, and that must be done within a certain timeline. And if you do not meet your timelines, your claim will be dismissed, but it is dismissed without prejudice, so you can refile that claim with the CCB. So we wanted to pause here and see if folks had questions. We got a lot of good questions in the chat. Maybe we could shift to maybe folks answer or asking if they feel uncomfortable in person, or we can just look through the chat for maybe the last couple and see if we can answer those as well.
Yeah, if there's no hand raised, I can start reading some that were from earlier when we started, if that's okay. And if we have any hands raised during that time, then I'll move to a hand and then alter to a chat question. Is that okay? Great. So we have one from Lisette from earlier, and I want to make sure we capture it. So this is, so thanks Lisette for your patience and with us. So here it goes. I'm not sure it's accurate that only artists can register with the Copyright Office in DC. My publishing house actually did that for a book. Can you clarify?
Yeah. So that's a great question. Maybe to hop in, when you are filing for registration, there's different parts of that form that you can choose for like who is designated to file it for you. So you can have an attorney file it on your behalf. You can have an organization file it on your behalf. But you typically want to give permission. So like people can't sort of file it without you on board. So in your case, with the publishing house, if you kind of consented to that process, then yeah, that's kind of built into that paperwork. And there's actually a form digitally that you can access for registration, and you can kind of step through it and just put in like temporary text to kind of advance through the form if you just want to look at it. But yeah, there is like a specific portion for that.
Oh, thanks. So still not seeing any hands up. So I'll just move on to the next one I have saved in the chat. So this is from Anna. If an artist discovers copyright infringement, do they have to send a cease and desist before filing a lawsuit?
Yeah, from what we understand, I think the answer is no. Yeah, but if anyone else has anything to hop in.
I think to add to what Karen said too, so one of the advantages of filing a cease and desist is that you can avoid maybe proceeding through the CCB or with filing a claim. So if it does in fact work and the other party stops that behavior, then great, and you've settled essentially without having to litigate or go through the CCB. So that's one of the advantages of filing a cease and desist.
Thanks, Annie.
Hey, I have a question that I think is kind of related to this same question, which is at what point should the CCB be engaged? I was confused by the talking about serving somebody. So I think serving is giving official legal notice that they are a respondent. And it says that the CCB would give, like if we're going through the CCB to bring an infringement case, for example, the CCB, if they move ahead with it, would give us the papers to serve and tell us to hire somebody to serve. So at that point, though, we may have already notified the person, right, that we believe that they're infringing, or we might have filed a cease and desist unsuccessfully or something else. Can we still use the CCB? Or is there a point where we could not use the CCB because we've gone too far down, like maybe another legal process or some sort of notification process?
Yeah, your intuition is spot on. There's basically this concept of like finality and this idea that like you can't use the CCB if you're simultaneously in another court trying to like respond and resolve the same exact legal question. So if you brought this claim to a federal court, then yeah, that would foreclose your opportunity to bring this to the CCB. But you might choose to go to the CCB first, and if like the respondent opts out or something else doesn't work out the way you want, you can have the claim dismissed here and then move on to a federal court after. But yeah, you don't want to have a final decision on this and then be bringing this claim, it'll be thrown out.
Yeah.
But
And
then, oh, sorry, go ahead.
oh, I have one quick thing to add to what Kieran just mentioned. I don't know if we called this out earlier, but for both the court and the CCB, you don't need to hire an attorney. So you never need an attorney to represent yourself in court, and you don't need an attorney at with the CCB. But one of the advantages of the CCB is that they've built the system to enable you to file that claim kind of in a way without having that mediator in court with, you know, it kind of removing the attorney fee issue if you want to maybe, or barrier. So just to call that out too, you never need an attorney, but the CCB does kind of make it easier to go without one.
And like, if you did go forward with a cease and desist, it wouldn't block you from pursuing with the CCB, just to, yeah, get back to the same.
Okay, so if the cease and desist is in process, either it's been considered or it's been granted, we can still do the CCB because the CCB does not do cease and desist. Is that correct? Like it's a different, it's a different legally, like it's a different matter.
Exactly.
Yeah.
Okay, great, thank you.
Okay, do we still have time for a couple more from the chat before moving on? Okay, so another question from the chat. This is from Alice. This is from earlier. So thanks, Alice, for your patience with us. What exactly is opting out? If I were accused of copyright infringement, why wouldn't I opt out?
Yes, that's a great question. So I think somebody actually brought it up in the chat too. So the respondent does have the right to opt out, but say your claim doesn't move forward with the CCB, we imagine that you might then proceed to try to file in court. And so the respondent in that sense is incentivized to opt in through the CCB because they're also incentivized to try to resolve this issue online as opposed to having to appear in court. And so that's kind of one of the reasons respondents likely may not opt out. And again, in thinking about the differences between federal court and the CCB, damages can be much higher in federal court. So again, respondents are probably incentivized to maybe want to proceed in a forum that caps damages at 30K.
Great, thanks, Caitlin. And so this is another one from earlier from Annie. I'm not sure if this was answered, but I'll go ahead and just say it again. What time period does the CCB data cover?
Oh, yes, I will pull this up. Maybe when we're doing the breakout rooms, I can just reference it. It's like a date range, and I just don't want to make it up. But it was since the beginning of the CCB's founding until around like February of this year. But I'll pull up the specific date range. It's around between 2 and 3 years of data.
I think, yes, I see June 2022 until October 2023.
Sorry, so that was like 721 cases filed between June 22 and October 23 and like 18 months-ish. Is that right?
Oh, I think that was, sorry, were you referring to the number of claims that didn't proceed? This was about the data, the infographic.
Yeah, I couldn't tell if that was like per year or since it's like, I'm just curious to know how busy they are.
I see.
I'll copy and paste the date string.
Yeah.
Okay, thank you.
Or in breakouts.
I think we should move into the activity. We may need to adapt it a little bit, if that's all right with you all. I also really want to recognize that people are explicitly saying that their brain is a little bit melted too. So maybe what we could do is we had planned an activity to walk through some of these cases and claims with you all, excuse me, not case. But what we could maybe do is maybe spend the next 10 minutes going over one that feels most interesting to you all as a group rather than breaking out instead. So what I'm going to do, I'm sending you all in the chat the activity sheet that Caitlin, Karen, and I prepped. I don't know. What do you two think? Should you all just pick one that actually feels like it might be the most like best for learning here, or What do you all think for walking through this activity as a group? I think that might feel a little bit better in the next 10 minutes or so.
See.
I don't have an intuition on which one might be like the strongest. I think there's a lot of overlap between the kinds of things we'll have to think through for either. So, yeah, also the kinds of claims, each activity corresponds to a claim type. So one's non-infringement, one's infringement, and one is misrepresentation. But if anyone has like particular preferences, and you want to vocalize that in the chat, also feel free to let us know.
Yeah, maybe in the chat, if you want to go dive deeper into infringement, non-infringement, or misrepresentation, put that in the chat right now, and then we can pick accordingly. Let's do that so we can all have it as a group. Ooh, any infringement. Yeah, infringement. Sign is pointing towards infringement, y'all, which I believe is Priscilla, right?
Okay.
Yeah. So I think we're gonna walk through Priscilla. I'll hand it back to you all.
All right. So Priscilla is an up-and-coming painter. To get her work out into the world, she usually posts paintings and process videos on Instagram. And one day she saw somebody selling a print that looked awfully similar to one of her paintings on Amazon. So Priscilla believes and has kind of expressed that she can no longer sell her painting because poster that's now on Amazon really devalues her work. It's not recognizing the labor that she put into that and the thoughtfulness, and should she consider moving her claim into the CCB? So our questions that we wanted to talk through together are, what kind of claim could this be? We might have given that one away already. But yeah, what kind of claim could this be? What elements would you need to prove? And what kinds of evidence would you submit to the CCB if you were Priscilla? So I know we all know this is an infringement claim. And this is not an exercise in memorization either, so we can pull up the elements again, and maybe we can just talk through those given Priscilla's situation. All right, so I'm going to go back a couple slides and open that up. Let's pull up the elements. Okay, so there are a couple elements for infringement, as we discussed before. First one is valid ownership. The other one is that one of your exclusive rights were used and without your permission. And the third one is that it's substantially similar. So what kinds of things would you consider bringing up or kind of looking into if you were Priscilla?
I wanted to actually add here too, so we got a good question from earlier about damages and about demonstrating lost profit. So in thinking about all these different elements, it might be good too to think about how you might demonstrate to the CCB why you're asking for the amount that you're asking for. So what are other pieces of material that you could add to kind of demonstrate the damages amount? And we can talk about that as a group as well.
I have a question that might be kind of paranoid, but is it possible that by posting a work to Instagram, you've lost rights to the work?
Yeah, so great question. If you can have copyrighted work that you share, and your rights are about your exclusive ability to reproduce that work or share it in certain settings or to perform it. And so if you have your protections, you can I think post to Instagram and not be losing those rights and forfeiting them. But again, I think I don't want to say this as a broad statement, because in particular, a lot of platforms have their own terms and conditions that sometimes will sneak in a little paragraph about how by using their product, you also share your exclusive rights with them when you post something. And so you want to be pretty attentive to what each platform's rules actually are, because just by posting something, you might actually be, forfeiting those rights if that's part of the terms. But whether that is, specific to Instagram, I don't know off the top of my head, and so definitely would welcome, yeah, anyone else who knows for sure.
Yeah. I think that's a great question. I think, like Kieran mentioned, every company has their own terms and conditions. I think it does depend a little bit too on, like, say you're using that tool to create the work. So like a TikTok video, I imagine those rights are probably given to the company because you're using their tool and it's on their platform as a form of the creation process. And so that's probably a little bit trickier. But if you make a painting and then post the painting, you don't lose the copyright protection simply by posting somewhere else. The separate image of that work on that platform, I think, would be considered almost like a separate work. And but that doesn't give someone to borrow elements from your original work within that work, if that makes sense a little bit. So there's kind of like two nested works there. But again, with these social media companies, I do think they own some copyright over or ownership over anything that's like within the platform itself.
Maybe to add in like a note from Phil, it's a common misconception that people are free to kind of recirculate and copy things on these platforms, but those are not actually natively rights that you might have, even though it might seem like it.
Yeah.
All right, so we've got a couple of comments and a hand raised. Maybe Anna, do you want to share your question?
Yeah, so this definitely relates to the question that I was asking about, like, if an artist who is probably unknown and doesn't make a lot of money from their work has their work infringed by someone who maybe has tons of followers or has a lot of money or is a corporation, what position is that artist in? Because it seems like, I mean, I guess I don't fully understand, like, are we saying that that artist's work can just be exploited and that artists cannot get the full value of how their work was exploited because they weren't, maybe they didn't have the systems in place to license out their work, or they didn't, and I think this is especially important for emerging and independent artists because it kind of seems, like with generative AI, if I have like 100,000 followers, right? And versus if I am an artist who only has like a few hundred followers, someone with like the 100,000 followers could then take my work and make a lot of profit from that work, right? And I might not be able to gain the full value of that because I didn't have 100,000 followers.
Yeah.
Is that correct?
I think I want to make sure I understand the question. So is the question about kind of the power dynamics between the copyright infringer and the copyright owner, and whether or not those are important in bringing a claim in the CCB, or is it about proving through following? Is that kind of the issue, or is that the question? I want to make sure we captured it totally.
I think there was a slide where something was said about sorry, can you hear me pretty well? It sounds like you can.
Yes.
Okay.
Yes.
So there was a slide where something was stated that it also depends on the extent to, like, you have to prove, how much you would have made from your work, right? So if you're someone who is regularly licensing out your work and getting a certain amount, then that's a lot easier to prove, right? Versus if you're someone who's relatively unknown, then it seems like you're in a much more vulnerable position. And it just seems like in that case, like, there's a lot of incentive then to go after artists who are relatively unknown.
I see. That definitely, I think that you're right, that there is probably, that does happen. But if you say your work, if your work is infringed and say month over month, you demonstrate that, you've earned maybe X% in profit from that work, and then that profit dramatically changed post infringement, and this larger kind of artist with a larger following earned maybe 4x times what you typically earn, you can still demonstrate that that profit that they earn is something that you are owed as well. So you get profits, not just losses, in your when a larger maybe body or artist infringes. If that, so in that sense, you kind of can earn whatever is commensurate with that, like following that that person has.
There's also,
Okay, so
yeah,
oh,
go ahead.
sorry. Go ahead. Well, I was wondering, so you would be able to reap the profits that the person who infringed upon, you would be able to get those profits regardless of like whether you normally make a lot less.
Yes.
Okay,
Yes.
thanks.
But the other thing I was going to add on was like, I think it was for non-infringement, or sorry, actually, take that from. For some of the claims, if you have to show that you were actually harmed, just because like if your month to month earnings are lower than some more high profile or like powerful sort of institutions earnings, if you can still show that you were relatively harmed compared to what you typically make, you can still show that you have suffered losses. So it's not like your claim is suddenly a lot weaker because it's not meeting this like absolute standard. It's like relative to your own earnings.
Okay, I think I probably still need to learn more about it because I guess I'm not fully understanding. To me, it just seems a little strange that it matters, like that it matters at all. Showing that you had, to me, it seems like it makes more sense to just have a like dollar amount because there are artists who literally don't make any money. But you know what I mean? Like artists, it's very difficult to make money from art. And so there are artists who might not even be able to show
Mm-hmm.
that they were making money to begin with, but someone else could still use their art and make a lot of money, because a lot of like an ability to make money from art right now is more about your popularity and how much money you already have to begin with.
And maybe piggybacking off of that, like reputational harm can also be something that has financial value. And so if your brand or like your identity as an artist is also challenged because of this act, like those are maybe things you can draw from as well. I think you're totally right to point out that a lot of the legal system in general is really about like trying to financially like label the value of something to then prove that there was harm in the first place. So that is something that is somewhat present here, but yeah, there are maybe other avenues you might look at to creatively sort of establish that for yourself too. But it is like a sort of unfortunate reality of what kinds of things can get their foot in the door in these sorts of cases.
And adding to what Kieran just said too, I think so. If say you didn't earn anything off of that work, say it was a graphic image and then it was put on a t-shirt and a big company earned immense profit from that infringed work, you could just demonstrate the profits that they earned, and then so you don't need to demonstrate lost profit or losses. You could just simply demonstrate profit, and then in that sense you would be owed whatever that amount is, or up to the court however that amount is at the CCB, of course, knowing that that cap is 30K.
Okay, thank you so much.
Okay, so we wanted to just maybe circle back to this and see if folks had thoughts on this case, and then we have a couple notes at the end, and then if we have extra time, maybe we could move into some of the remaining questions as well.
Alice, would you like to share?
Yeah, I just had a question related to our last scenario of t-shirts being sold. So when you file, do you need to include a dollar amount? Because, yeah, say someone is selling t-shirts of your work. Yeah, how do you even go about finding out how many sales they made to put in this claim? And if they're continuing to sell, the number is fluctuating.
Yeah, that's a great question. And yeah, I think you're also pointing out to this sort of part of this whole process, which is like there's a lot of information that you just naturally wouldn't know yourself. So how are you supposed to even prove it? And so there are some things that upfront the CCV will kind of just want to know as you're filing the claim to begin with that you have a strong basis to believe that you have a good claim here. But a lot of things come out later in the process in the proceedings phase. So one part of that is discovery, and that's when if there are things you want to compel the other party to produce, like you ask them for records about their sales and how long they've been selling this shirt for, and like all of the store pages that they've had, or like records and receipts. Those are things you can kind of get out in the open in that part of the process. And then you'll also have the CCB sort of presiding over it. And so there's like a legal body that's observing and kind of there facilitating that process. So those are moments in this process where you can kind of compel some information to come out. But that could also be true for other things too. So you can imagine there's in the non-infringement case, you might want to show that the person is telling other people that that you've infringed on their activities. Like you can't really get into their private messages if that's where it's happening, but this could be a place to explore getting evidence that you need. Great. Any other questions? Annie.
Hey, this is a general question. Are we at the, is that okay? I feel like I have so many. Thank you. At some point, there was something about the statute of limitations being 3 years after the start of infringement. And does that mean that if someone's been, let's say, distributing a work for 10 years and infringing on a copyright for 10 years, but I only discover it this year, does it mean that the statute of limitations has passed and they can keep distributing that work forever?
No. So I think that's a great question. I think every single time that they infringe on your work, it's a separate act. So if they keep repeating this, yeah, you are only entitled to like the 3 years since you discovered. I think, but yeah, would also invite Bill or Nina to step in if they have.
So if they distributed something like 10 years ago once, then it's past the statute of limitations. But if they're like distributing something like on a streaming service or on Instagram or somewhere where it's continually being distributed, then it's like then it's
Yeah.
a current.
If they listed things one time and it just remained online, that was a single act. So if something was, put up on Spotify 10 years ago and you just find out about it, that's all a single act of infringement. And so once the 3 years are passed, you cannot go and claim anything there. But if they keep like popping up on different platforms and listing things and you are within the 3 year limit, then that would be valid. So it depends more on the specific instance of it and then when that began.
I mean, in the Spotify case, they're in theory actively collecting royalties for things that are happening this year. So it seems like it would be current because they're like people are currently.
Yeah, I definitely get the tension you're talking about here. I think that we'd want to look at the act of when the music was posted.
Okay.
And that's the date you want to look at, not like when they're sort of benefiting from it.
Okay.
Annie, this is Phil. The one thing I would add to that, there is this thing that a lot of courts apply called the discovery rule. So if, let's say, somebody posts your photograph 10 years ago and just leaves it up, as Kieran said, that's a single act of infringement. So it doesn't like restart every day. But if you don't discover it until a year ago, and there was no reason that you should have discovered it sooner, then the statute of limitations doesn't block you out. As long as you discover it within the last 3 years, then you can still sue. And usually you can sue going back from when they first put it on, but it's only a single act of infringement. It's not like it starts over every day and you get to get new damages for each day. But it is possible that somebody can put something up years and years ago and you can still sue them for it in spite of the statute of limitations if you don't discover it until sometime in the last 3 years, if that makes sense.
Thanks, y'all.
Maybe we'll take one more question and then wrap up. Jillian?
Hi, yeah, I was wondering, how you tell substantially or substantially similar? Like, is there a percentage? Is there a certain formula? Yeah.
That's a really good question. It's tricky. I think it's a tricky question. I don't think adding a percentage, although I'm not sure how you would calculate that, would be harmful to your case. I think that would be interesting. And it is interesting to think now, actually, with new tools like ChatGPT, if they could calculate that. I would be curious to find something out like that. But it is.
Remember in the like early aughts in undergrad, I was in like a graphic design class, and I feel like the teacher said a certain percentage, but I don't know if that was like fact or not.
I don't know that you have to add a percentage. I think it would be helpful if there's a way to calculate that. And always substantially similar is fact specific and it's case specific. So it will be up to the CCB to determine the substantial similarities given the material facts that you present to them. But I think adding in, I mean, for example, with a musical piece, I think like even just demonstrating, for example, musical notes in certain areas that have the exact same type of structure as your piece. And this is kind of where in courts, people might bring in, you would not do this at the CCB, but an expert witness would kind of be able to demonstrate those similarities. But at the CCB, kind of acting as your own expert witness to say, here's evidence or demonstrations that these 5 notes were used repeatedly throughout the piece at these points as it was in my piece. And so you're just trying to create those substantial similarities to someone who's unfamiliar with your work.
And I think like building on that in the graphic design context, for example, like maybe there are color palettes that are like so core to your identity as an artist, and maybe you have like stylistic things that you do, like you maybe use a lot of like sharp angular edges, or you like lay out your art in a specific way with certain types of themes and content, or the lighting is done in like the texture. There's like so many different sorts of angles you might want to look at, but because of how case specific it is, it's really hard to generalize or create some sort of like rule that applies to everything. So you'll really want to think about like your art in its own context and your identity as a creator, and like the types of methods or techniques or like visual choices that you make.
Yeah. I think with tools now, it's useful to say, like what Karen just mentioned, say you use one hex code and the other person did as well. I mean, just adding those types of details into your material statement of facts, I think is really useful to show those substantial similarities. So if you can kind of get the specificity into that statement, I think that helps to add to that demonstration that the two things are very similar.
Great. Maybe we'll take this moment to wrap up real quick then. So we wanted to share some key takeaways. And to start with, only registered works of copyright can be legally defended, especially in the CCB for infringement claims. This is a requirement, so you cannot bring an infringement claim without registration, or at least a pending registration. And then the CCB is a streamlined small claims board that oversees these 3 types of claims that we've been over together. And the CCB is designed to be easier to navigate, so fully online, meant to be navigated without an attorney, and does present some trade-offs that you might want to think about. And finally, if you file this with the CCB, remember to meet the deadlines, check that you're actually following the rules and requirements and trying to meet the elements of your claim so that the substance of your claim is also stronger. And of course, in our classic sort of, legal structure, we wanted to share again, this is not legal advice. And a lot of the things you might run into are going to be really case specific for you. So we don't want this to be intended as, a broad set of rules for what you should do. Definitely recommend you to think about your own case, consult with an attorney if you think that you, want to pursue something and need more information. And it really all depends on what your case is. So yeah, don't want to overgeneralize with anything. Yeah, maybe we wrap and send it back to Jenny Lynn.
Yes. All right. And so finally, again, we recognize like these legal issues, when you're in it, it can make you feel so alone, but you're not alone. Here are some more legal resources that are out there. And outside of legal support and other issues that artists experience, I want to remind you all that CCI also actively updates our emergency resources for artists document, which is placed in the chat by my colleague Lorena, and it covers a wide range of issues that impact artists too. Next slide, please. And finally, thank you. I really want to encourage you all to use that chat, the reaction, clapping reaction, to just share in a thank you and gratitude towards our fantastic trainers. Round of applause there. Thank you to Stanford University's JPIC. Thanks, Phil. Thanks, Nina. Office of Copyright folks, if you're still out there, thank you. And a couple reminders that we're going to be putting in the chat here is that in 2 weeks, we're actually going to be hosting a copyright registration party where you can see us go through. We actually took a little video of registering the resource guide itself, and we can show you how we did that. And you can just meet other artists and we can share more resources as well. It's just a short 1 hour time to share space together and do things to protect ourselves. In addition, as I said at the top of our time together, share your story. We're going to continue to work with JPIC students on issues related to IP and copyright. So we want to hear from you so that we can share to all the amazing students over at Stanford what you all are experiencing. What are the highest needs? What are some patterns? What's going on? What's keeping you up at night? So that we can figure out how to best support you. And of course, fill out our evaluation, please. We care about doing well for all of you. You're the reason why we do this. So we want to hear your feedback of how this was, what really resonated, what you're still curious about. And again, just thank you so much for being here today. And with that, have a great afternoon. Bye. Bye, y'all.